This is episode number 20 of the Inland Empire Workers' Compensation Lawyer live stream podcast, broadcasting live every Sunday at 3 p.m., discussing a new topic in workers' compensation and employment rights. If you work in California, you should be connected to this channel so you don't miss out on important discussions that affect your legal rights. Please, what did I say next?
Like and subscribe.
Like and subscribe. Hey, make sure that you like and subscribe to our channel if you work in California or you know someone who does. So if they get injured at work, you have a resource that you can connect them with. That's why we're putting these videos out. It's for educational purposes. And if you are injured and you come across our channel, you can give us a call at 844-984-8414. That's our injury helpline. Don't forget to like this video if you find its contents useful. Smash that like button. That's what we need so that others can also see this content and be exposed to our discussions that are going to help them if they become injured at work or if they are injured at work. So with that being said, let's get into the discussion for today, episode number 20, which is on presumptions. You might be wondering, what is a presumption? How can it help me if I'm injured at work? That's why you need to watch this short episode that George and I have put together that's going to enlighten you and help you make the decision that you need to speak with a lawyer. Because remember, it's not legal advice, it's educational only. And if you've been injured in California, you need to give us a call, 844-984-8414. So normally, when you have a workers' compensation claim,
Right.
you have the burden to prove that you were injured at work and that you're entitled to benefits.
Correct.
But there are certain situations where there's a presumption that
Right.
the employer is liable to pay for your injuries and provide you with benefits.
Today we're talking about just a shift in the paradigm. Not the employee having to prove their injury, but now the employer having to prove that it was not work-related. So that's very interesting. And I do want to mention that this is a teaser. This has so much information involved that today we wanted to open up the topic. Okay, we're going to discuss a little bit about it. We're going to give you some great information. But what we're going to do is make a full-length video on this topic because it affects maybe a loved one or a friend.
So, George, we were going through some of the situations
Right.
that give rise to this presumption. You were mentioning police officers.
I was. There's certain types of employees, Alex, that because of the work that they do, it's presumed that they might suffer from different types of injuries, right? So the two most common ones, and there's a lot more, which we'll go through, is police officers and firefighters. So police officers, this can range from a probation officer, city police officer that's out on the job. Maybe they are sheriff department. So it's a lot of different types of civil servants, we call them, right? Police officers, they're out on the job. They are exposed to some cancer-causing agents, cancer-causing products, more often than most of the population. So because of this, it was enacted in the Labor Code, a provision that's going to give them a presumption that's going to allow them to say, hey, I was injured on the job. And now the employer can't just say, no, prove it. Now they have to say, no, you weren't, and we're going to have to prove it. So that's what a presumption is. A presumption is you're assuming that it was work-related until you find out that it's not, right?
Right. It's a rebuttable presumption.
Correct.
So the employer, as you stated, has the ability to prove that it's not work-related, but the injured worker coming right into it shouldn't have to prove that it's work-related because it's the type of injury that you would expect to happen due to the increased exposure of that type of work. It's the public unions bargaining with the legislature to have these presumptions.
Right.
I mean, there are a lot of workers in California who are exposed to chemicals all the time. Maybe not as much as firefighters, though. Like a firefighter is going into a fire consistently. Is going to be exposed to smoke and whatever's burning in there.
Right. And you also make the argument that police officers, they have to deal with handguns on a daily basis, right? You have to clean them, you have to shoot them, you have to practice, even if they're not pulled in the line of duty. You still have to be very comfortable with firearms and other, who knows, pepper spray. We don't know the exact type of chemicals that they have to go through with their training and things like that. But definitely in handling the bullets, the lead exposure, all that kind of stuff, then it does make them more susceptible to those types of injuries, right?
Exactly. And that's why the labor code allows for the presumption.
Right.
So the information you're getting here, it's general information only. If you're a police officer or a firefighter and you need to have some questions answered about the specific facts of your circumstances, then you should call the injury helpline. But you should also finish off the discussion here so you have a better idea about what kinds of presumptions you could be entitled to.
Definitely. And like I said in the beginning of the video, Alex, this is a teaser because this information is not only extremely important, but it's very detailed and there's a lot of it. So we're going to be coming up with a video that's going to be a lot longer, but for those interested, it's very, very good information, useful information. It's stuff like, hey, I'm a lifeguard for the city. Are there any presumptions? Well, yes, there are. You know, lifeguards are in the sun all day. You might be susceptible to skin cancer, and cancer is one of the presumptions. Skin cancer, cancer in general, heart conditions, those things are part of that. And we have a whole list to go through to explain to our audience. And like I said, we will be putting out a video much longer with a lot more information. So please stay tuned for that. For now, we want to bring this topic and kind of let you sit with it until the other video comes out. But if you have any questions, comments, concerns, always reach out to us.
You need to establish some things to actually get the presumption. You don't just walk in and say, well, you know, you have to prove that it's the type of injury that falls under the presumption. You might have to prove that you had some exposure as well. If you're a normal worker, if you're a regular worker, and you file a workers' compensation claim, and then later you get a denial, it could be that the denial is late.
Right.
And if the employer doesn't deny your claim in the correct amount of time, which is 90 days from the date that you submit the claim form to the employer,
Correct.
then the burden shifts to the employer to prove that you did not get hurt at work. They cannot deny your claim. So if you've received a denial, the special thing about the presumption is that it could shift the burden to the employer to prove, no, you can't deny this claim. I'm going to go get a lawyer, call the injury helpline, get a lawyer, and my lawyer is going to file for a priority conference and tell the judge, hey, we can establish that the claim form was transmitted to the employer on a certain date, and we can also establish that the employer denied the claim on a certain date, and that period of time was more than 90 days. Boom, automatically burden shifts to the employer to prove that the injury did not happen at work.
Right.
And if there are benefits that should have been paid to you, those benefits could be subject to a penalty against the employer for late payment of benefits. Now, there's a lot that goes into that. The employer can still argue that there's no medical evidence to establish that you were entitled to any benefits during that period of time. So it's also important that you're seeing a doctor and that you're serving those medical reports on the doctor. So if you've been injured at work, I think the safe bet is to call the injury helpline, dial 844-984-8414 to speak to a lawyer about the specific facts and circumstances of your case.
And I think that our viewers have taken the first step by watching our videos, because this is the first step. Watching our videos, you get great information, but I think that it's a lot of information and you need to actually speak to us in order to know what to do with that information. So a consultation doesn't hurt. It's free. Give us a call. I think that after the consultation, if you feel like you want to handle the claim on your own, then that's your decision. If not, at least you got the first step of advice from an attorney. And if you do feel like you want to be represented, then obviously we would love to help you out. We've helped out thousands of people, and we'd love to guide you through the process.